Well, good evening, everyone. Thanks for coming out this evening. Hope the storm and some of the high water didn't get in your way. My name is Warren Elliott, and I am the president of the Pennsylvania Fish and Boat Commission. On behalf of my fellow commissioners, and we have two with us here this evening, we have Commissioner Bill Sabatos back in the back, and Commissioner Bill Warbeck. Gentlemen, thanks for coming, and I'd like to welcome all of you to this special event. The Ralph Abele Conservation Heritage Award is the highest honor bestowed by our agency on Pennsylvanians who make a lasting difference for aquatic resources. We take the resource-first philosophy that you see posted on the outside of this room seriously, and there are a few individuals who represent that idea more than our award recipient, Senator Franklin Kury. Following the award presentation, we will air an interview that was pre-recorded with Professor John Dernbach from Widener University. We will then shift into what is sure to be a lively discussion about the lasting impact of Article 1, Section 27 of the Pennsylvania Constitution. We are delighted that Pete Duncan, former Secretary of the Department of Environmental Resources and Executive Director of the Pennsylvania Commission, has agreed to moderate the discussion. And we are happy to welcome Terry Bossert, former Chief Counsel at the Department of Environmental Protection and currently with Range Resources, to join Senator Kury and Director Arway on the panel. You have probably noticed the camera in the room. WITF is taping this session, so be on your good behavior and don't do anything you don't want to be seen on camera, as part of an ongoing project to document significant achievements and people in Pennsylvania's rich conservation history. We appreciate WITF's interest and willingness to join us here tonight. So congratulations to Senator Kury, thank you panelists, and thank you all for coming. To present the award, I'd like to introduce our Executive Director, John Arway.
Thanks, Warren. And I'd like to join with Commissioner Elliott and welcome everyone to the Fish and Boat Commission's headquarters this evening for this special event. Without a doubt, being part of tonight's ceremony is one of the best parts of my job. Ralph Abele had a huge impact on my personal life and career, and I'm honored and humbled to be in the position to present this award in his name to another giant of conservation here in Pennsylvania. I know that Mr. Abele is here tonight in both spirit and substance, since I'm wearing a necktie bearing his favorite slogan from the Gadsden flag, "Don't tread on me." Although this slogan has also been borrowed by others for use for different purposes, it remains Ralph's trademark. The tie I'm wearing tonight was given to former Commissioner, Pennsylvania Fish Commissioner Bob Martin by Mr. Abele, and Bob gave it to me when I became director. Mr. Abele liked to tell us to do our duty and fear no one. If there was ever a person who did his duty for the Commonwealth's natural resources and feared no one while doing it, it was our honoree tonight, Franklin Kury. As a legislator from rural Pennsylvania, Senator Kury saw firsthand what could happen if we did not protect the bounty of Penn's woods and waters. Rather than sit back and watch from the sidelines, he took bold steps while in office, helping to lead successful efforts on issues such as the State Scenic Rivers Act and the Floodplain and Stormwater Management Acts. Senator Kury was a tireless champion for both the people and the natural resources he represented. But there is one achievement that sets Senator Kury apart from anyone else and led us to select him to receive this award tonight. As the author and champion of Article 1, Section 27 of the Pennsylvania Constitution, he embodies the very accomplishments intended to be recognized by this award. Two of the nomination criteria for this award are particularly applicable to Mr. Kury. That the person has, quote, led an effort to pass major environmental legislation for the protection, conservation, and enhancement of the natural environment of Pennsylvania, or, quote, led a regional or statewide environmental effort that has been recognized for its duration and success in protecting and enhancing the aquatic resources of Pennsylvania. Arguably, there is no more significant piece of environmental legislation ever passed in Pennsylvania than what Mr. Kury and his colleagues, including Mr. Abele and many others, did with this addition to the Pennsylvania Constitution. This accomplishment is certainly major in reach and impact that it has had, and its duration is timeless as part of the very laws that guide our Commonwealth. Indeed, the incredible legacy of Article 1, Section 27 and its relevance today is the centerpiece of a recent groundbreaking Pennsylvania Supreme Court decision places Mr. Kury among the most significant leaders in Pennsylvania's rich conservation history. On behalf of the staff and board of the Pennsylvania Fish and Boat Commission, the board of directors of the Ralph Abele Conservation Scholarship Fund, and the current and future generations of Pennsylvania anglers and boaters, it is with great pride and gratitude that I present the Ralph W. Abele Conservation Heritage Award to Senator Franklin Kury. Congratulations. Thanks again.
First off, I just want to say thank you. I knew Ralph Abele. Ralph Abele and I were good friends. I'm very proud to have been a friend of Ralph Abele's. And I know how hard he worked when he came to Pennsylvania to work for the House of Representatives. And I know how hard he worked at the Fish Commission. In fact, one of my favorite portraits in my mind of Ralph Abele is actually seeing him on the Delaware River in shad season in a Fish Commission boat with a steel pot and a life jacket and his arms and a shoulder of some kind, I think it was a shoulder pistol, going up and down the river like General Patton on a waterborne Jeep. Oh, and it was a patrol boat, not a Jeep. But nobody worked harder to make Article 1, Section 27 a reality than Ralph did. Nobody did more to promote it. And as you'll see coming in the door there are these little placards that Ralph passed out. He put it in the Fish Commission bulletin. He put it on office walls. He really was a devoted champion of the amendment and what it stood for in Pennsylvania. So I am honored and thrilled in Ralph's name to accept this award. Thank you very, very much. But I do want to say a few words, and I want to make a point. I appreciate all the senator stuff, but I'm going to speak tonight as a House member because this amendment is a House product, and it came out of the House of Representatives, and all the Senate did was agree to it. So I could say that. But let me say that this amendment, Article 1, Section 27, is a product of the environmental revolution that took place in the Pennsylvania House in the 1968, 69, and 71 sessions under the chairmanship of John Laudadio. And I was fortunate to be on the committee as his secretary. We passed more environmental legislation in 4 or 5 years than we did in all the history of the state put together. And we did it because we wanted to overturn a century of brutal exploitation of our air, land, and water by the coal companies and the steel companies and the others that just blatantly exploited our landscape. So this amendment came out of that. And while this was going on, the lawyer in me said, we need something that's going to stand the test of time. These bills which we passed, clean streams, scenic rivers, strip mine laws, all those things are great bills, but they can be amended. But a constitutional amendment should have more permanence. So that's where the idea came from and how it got into that package. But I want to make just 3 or 4 points, and I'm going to let the rest of the panel get going here, but I want to just say a few more points. First of all, the amendment had tremendous bipartisan support. We had both sides of the aisle supported this bill. There wasn't a single vote against it in either house. In the House, we had 5 speakers of the House as co-sponsors. The then Speaker, Herbert Feynman, 2 future Democratic speakers, and Leroy Irvis and Jim Mandarino, and 2 Republican speakers, who were Matt Ryan and Jack Seltzer, co-sponsored the bill. And Snuffy Smith, the father of the current speaker, co-sponsored the bill. So we had very strong, outstanding support on both sides of the aisle, and it went through both sessions. It was amended several times, but the basic idea, we had no negative votes. So when the bill went before the public, as every constitutional amendment must do, in May of 1971, it had the support of the Pennsylvania Federation of Sportsmen's Clubs, the Pennsylvania Bar Association, and the Pennsylvania Environmental Council. And let me tell you the votes that day. It was very interesting. There were 5 amendments on the ballot. 2 of them were defeated. Here's the vote on women's rights, and I enjoy telling my wife about this. The vote for the bill the amendment to give equal rights to women was 783,331 to 469,520, 7-4, which is good. And I voted for it, of course. But the environmental amendment, 1,021,342 for, and only 259,000 against, 4-1. And that was, to me, a ringing endorsement from the people of Pennsylvania that they wanted a new direction to the environmental policy in Pennsylvania. They didn't want state government to be an accomplice to exploiting the environment. They wanted the state of Pennsylvania to become the trustee of our environment. And that's spoke loud and clear by that vote. That was an authentic expression of the body politic, speaking in outrage against a century of exploitation, but with the hope of better things to come. So I feel very, 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 very proud of that. Now, the other thing I want to make a comment on briefly before we turn to the panel is that we tried to write this amendment, as was laid out there, in clear, plain English. I mean, I think it's pretty plain. The people of Pennsylvania have a right to a decent environment. That's the first sentence. The second is that the public natural resources belong to all the people. And the third plain language is that the state of Pennsylvania is the trustee for future generations. Now, with the language being so clear in my mind, what surprised me is why it took the courts of Pennsylvania so long to learn to read English. I mean, I'm only partially kidding. But if you look at the Robinson Township case, and I'm sure you haven't, starting on page 72, the headline is plain language, plain English. And what the court did is they got through the language, said this is plain English, and you take it at face value. If you read any statutory law in Pennsylvania, there's a statutory construction law. It tells you how to interpret what the legislature means. The first thing is, what is the plain English meaning of the sentences used? And that's what was done here. And I'm very pleased and proud that the state Supreme Court of Pennsylvania, at least 4 justices, 3 deliberately and 1 acknowledging it, came through and said the plain language means what it says. The people have a right to a decent environment. The public natural resources belong to the people, and the state is the trustee of those for future generations. Now, the lawyer in me will add one other thing. The fact that it's plain English doesn't mean it's easily applied to the facts before it. I mean, you look at take the U.S. Constitution, the First Amendment, things like that, they're also plain English. But look at all the litigation that's taken place over it. So the same thing has happened here. Although the English is plain and the principles are quite clear, how you apply that to specific cases is a different question altogether. And at that point, I think I better stop and let the panel take over, because we have some very good lawyers here and they'll want to give their point of view on that. But I just want to say again, I am very proud to have been a friend of Ralph Abele's and to accept this award. And I'm even prouder to have had some part in putting this into the Constitution of Pennsylvania. Thank you very much.
Well, before we start the panel, we're going to play a video that John Dernbach Professor Widener did for us with John. But the panelists, maybe, if you guys want to sit in the front row there, rather than break your necks, however you want to do it. You get this queued up.
Welcome, John. We really appreciate the opportunity to get your perspective about a number of issues associated with Article 1, Section 27. And the first question I have is, where were you when you first heard about the Robinson Township decision?
I was in my office right here, and I got a phone call from Jordan Yeager, who's one of the attorneys that represented the petitioners in this case. And he said, there's an opinion, you should take a look at it. And I got the opinion from him by email.
Welcome, John. We really appreciate the opportunity to get your perspective about a number of issues associated with Article 1, Section 27. And the first question I have is, where were you when you first heard about the Robinson Township decision?
I was in my office right here, and I got a phone call from Jordan Yeager, who's one of the attorneys that represented the petitioners in this case. And he said, there's an opinion, you should take a look at it. And I got the opinion from him by email and downloaded it, but it all happened right here.
So when you read the opinion, what was your first reaction? What was the first word you said?
My first reaction was something in the nature of holy cow, okay. There are two things that were going on, I guess, when I read it. One is I was just struck by, here's a Supreme Court opinion that is taking Article 1, Section 27 seriously. And not only is it taking Article 1, Section 27 seriously, but it's tracking a lot of the stuff that I had written in a couple of articles 14 years ago. And which was really quite exciting. At one point, in fact, I was thinking, well, okay, so we're trying to think back to figuring out what exactly I had written back in 1999 in these two articles that they kept citing over and over again. And then I thought, well, I wonder if anyone has called Frank Kury to let him know about this. And so I called Frank, and he had not heard about it. And I got an email from him later that evening saying, this is exactly what we had intended, which was actually sort of very gratifying. But I felt like it was really important to call Frank.
It must have been special to deliver the message yourself.
Oh my goodness, yeah, my goodness. I mean, because what happened, when I worked at the Department of Environmental Resources, particularly in the 80s, there were posters of Article 1, Section 27 everywhere, and I went to presentations that Frank had given on and off at the Historic and Museum Commission and elsewhere, and I was very familiar with his role in drafting Article 1, Section 27. But the gospel, if you will, about Article 1, Section 27 for the longest time was it doesn't mean anything unless the legislature incorporates it in legislation. And if the legislature does incorporate it in legislation, then it means the Payne versus Gasab test, the three-part balancing test that the Commonwealth Court first articulated in the early 70s. And what was really fun and exciting about the Supreme Court's opinion was to see that they took the text seriously and they treated it as constitutional law. What they did, in other words, was they tracked what Frank had thought about and intended and worked on so very long ago.
Well, it's interesting. I'm not a lawyer, as you know, but I know a lot of lawyers like you and others that I really respect and appreciate advice from time to time. And I was always told in the past that if you included the Article 1, Section 27 argument in your pleadings, that it was like a grasp at something because you didn't have anything other substantive to argue, and because of the prior definition of what that meant. What do you think this is going to mean in the future now that we have at least a plurality opinion from the court about what the true meaning of the article is?
Well, I think for sure people are going to take the text more seriously. for sure they're going to do that. I think that the big challenge at the moment is that for a lot of lawyers, and I've talked to people who represent the gas industry and other clients in the private sector, and they agree with my assessment that it is as if Article 1, Section 27 had just sort of magically appeared in the Constitution on December 19th. I remember when I got done writing my articles years ago thinking, wow, I don't see the amendment the same way anymore, because I spent a lot of time trying to figure out what Frank had intended, what the legislative history of this, looking hard at the text and all of the rest of that. I remember getting done thinking, I don't see the world the same way anymore. And I think what has happened now since the opinion was issued on December 19th is lawyers all over the state and elsewhere are looking at Article 1, Section 27, and they're sort of in the same place, saying, wow, okay, the text has been buried for so long by this Payne versus Kassab test, and it's been buried for so long under the weight of all these various judicial decisions that have kind of set the amendment aside, that to some degree we're all looking at it for the first time. And I think the question, the large question that people have is, well, so what exactly are we supposed to do? There's some fairly straightforward things that I think come out of that, but that's the threshold issue is what do you do now with the text? And I think we're all, to some degree, feeling our way forward. I certainly have some ideas about that, but I think to some degree we're feeling our way forward.
One of the advantages I have now in my job is to be able to travel the country and talk to directors of fish and wildlife agencies from other states. When you take a look at this constitutional amendment, can you compare it to anything else that other states may have around the country that may be similar to it? And can we use that to judge the future for how this amendment, now that it's been reinterpreted, may change?
Well, there are constitutional amendments in a bunch of different states. There are public trust provisions that are somewhat similar to ours in other states. I think Hawaii is one. There are provisions that, constitutional provisions that contain environmental rights. And there are a number of states that have that. Very few states have as well developed a body of case law as Pennsylvania does. And the big challenge has been for environmental amendments in different states is courts have had a really hard time trying to figure out how to interpret and apply them. That's been a big problem with environmental amendments is how do you turn them into legal rules that you can make sense out of and apply. And so I think what has happened now with the Pennsylvania case is we're in a place now where the Robinson Township case, we're in a place now, I think, where Article 1, Section 27 is sort of back again in a fairly high level of prominence. And no, there aren't too many other states. The short answer, not too many other states that have an environmental amendment quite like ours.
How do we keep the momentum from the decision? I know it's going to probably be discussed in various courts and different interpretations by the defense and the prosecution will be given. But how do we keep the momentum of this decision alive?
Well, I think a starting point is agencies of various kinds, including the Fish and Boat Commission, just simply taking the amendment seriously and incorporating it into the way that it does business. I don't mean to pick on you, but I mean at DER, the Department of Environmental Protection, DCNR, other state and local agencies, in fact, including local governments. And so, for example, saying there's two sentences in the amendment that create a public trust in public natural resources and oblige governments to conserve and maintain those for the benefit of present and future generations. Well, government agencies at all levels, state and local agencies, could say, well, okay, so what public natural resources are under our jurisdiction? What does it mean to conserve and maintain them for the benefit of present and future generations? I mean, the Fish and Boat Commission already does that. You've got a great history of doing that. But including Article 1, Section 27 in your explanation of why you're doing what you're doing, I think is one way of keeping the momentum going. Acting, in other words, as if Article 1, Section 27 is truly and fully established. We've talked about the plurality opinion. There were 3 justices, not 4 for this. 3 is good. 4 would have been better. But I think we keep the momentum going to some degree by saying, well, look, there are some things that we have an obligation to do. Let's just do them. Okay, right, and let's keep doing them, instead of sort of hanging back and saying, well, let's wait for 4 justices.
Let's fast forward to today.
Yep.
I remember pulling the lever for this amendment when I was an undergraduate at Pitt.
I'm impressed.
And I was 21 years old. And do you think we have enough 21-year-old voters around to pull the lever today? Do you think this amendment could pass today if we voted on
I
it?
think it'd be really hard to pass this amendment today. I mean, in some ways, the environment is cleaner now than it has ever been. In 1971, there was a lot of stuff out there that was pretty nasty in terms of water pollution, air pollution, and all the rest. And you're a Pennsylvania native, you know the story better than I do on that. But I think these days it would be harder. There's a lot of sort of anti-environmental sentiment in the air, and I think it would be much harder. What Frank did that was so terribly important is there was a moment in time when this amendment was possible, and he seized the day. And the moment in time in the late 60s and early 70s when people were worried about the environment and all the different environmental legislation was being passed, he asked the question, can we take this to sort of a more permanent level of law? Yes, there's regulation. Yes, there's legislation. But let's try and body this in the Constitution. I think there was a kind of a magic moment then when this could be done. And I think it would be much harder to do that today.
You talked about Franklin Kury and his role with this, and I was at a conservation history project. We're trying to put together with WITF and others a framework to talk about Pennsylvania's conservation history, and it was great to listen to Franklin and Pete Duncan and others talk about the history of the amendment and what their roles were in its formation. And for all causes, you need a leader, and I think in this case, Franklin was the leader to champion this through the legislature. And I brought a copy of his book along and wrote a book about it, and a chapter in the book talks about the struggles he had with convincing some members that weren't as interested in the amendment as he was to vote for it. And it's a pretty interesting history, but
it's a great history.
When you look over time, how do you think Franklin rates in the history of conservationists in Pennsylvania?
Well, I'm not going to do kind of a top 10 thing, right? I don't know that sort of a ranking would be useful. There have been some very impressive people in Pennsylvania history, conservation history. Your predecessor, Ralph Abel, was certainly one of them. Gifford Pinchot, we're all familiar with, and there certainly have been others. No one else did what he did. And in terms of embedding the environment in the Constitution, that's a singular achievement. It's an achievement of a different kind. But if you say, where does he rank in sort of the history of Pennsylvania conservation, Franklin Kury's up there, for sure.
Well, if you have one thing to leave the audience with this evening about the meaning of this decision, what would it be?
The text of the amendment matters. It's constitutional law. And let's all work to make it stick and last. And so that we look back on Robinson Township and the moment that it was decided as something where the history of Article 1, Section 27 changed forever, where it came back from obscurity into something, relative obscurity, into something with vastly higher significance. And let's all work toward keeping it that way.
Well, thanks very much for your time and opinions, John, and I wish you the best on vacation in Wyoming.
Yeah, well, thank you so much. It's been a pleasure and an honor.
Thanks, John.
And congratulations, Frank.
very much, and congratulations, Franklin. There hasn't been a recipient of that award any more deserving than you, and we've known each other for a very long time, and I've been around through those wars and some of those wonderful achievements, and you deserve every accolade that is bestowed on you. One of the good parts about this evening is that some might disagree, but I bring a layman's point of view. I'm going to be honored by all these lawyers, with the exception of John, that will be commenting on the constitutional amendment this evening. But the perspective that I bring is that I too was around in those days, if just fresh out of the Army, participated in those deliberations with Franklin, other senators and representatives concerning the constitutional amendment. And I want to emphasize what Franklin mentioned a few moments ago. It was a very heady time for those of us who were interested in conservation and environmental protection. The truth of the matter was that we could not, as a staff, and there weren't many of us, there was Ralph Abel and there was me, and Beverly Smitley in the same office. It was at a time in the General Assembly when one representative, or 4 representatives had 1 secretary. Those days are long gone, but it was a very heady time for conservation and environmental protection. And we simply couldn't write legislation fast enough. That there were people from both sides, as Franklin mentioned earlier, both sides of the aisle lined up to be prime sponsors and secondary sponsors of legislation that had anything to do with conservation or protection of the environment. Contrast that today with the mere mention of science brings bristles on the back of many non-thinking individuals. Science was the key word to all the stuff that we were doing, and I'm not going to give you a litany of all of the things that were going on in those days, but think back to Project 70 and Project 500. Now, that's $70 million and $500 million for development of state parks and mine reclamation. Think about what that would mean in terms of today. And they passed overwhelmingly in voter referendums. Think of the constitutional amendment, the environmental rights amendment, passed overwhelmingly 4-1, Republicans and Democrats. So it was indeed a very different time, and those of us, even those of us who were young on the staff, understood, had a keen sense that this was a bubble, and that we better cram everything into this bubble that we could possibly cram into it, because there would come a day when it would be much, much harder. Never in my imagination did I think that it would come a day that would be as difficult as it is today, but I knew that bubble would not last at the time. For those of us, I'll rifle some of the Solid and Hazardous Waste Management Act with one of my favorite friends, John Carroll's wife, worked on to the wee hours of the night, and it passed by 1 vote after midnight when the speaker kept the tally open way beyond normal bounds. And Karin worked on that legislation. It was one of the landmark pieces of legislation. It was passed a little later in the 70s, but we got it done. The point I'm trying to make, the Clean Streams Act amendments, the Air Pollution Control Act amendments, Solid and Hazardous Waste Management Act, Wild and Scenic Rivers Act, the list goes on and on and on. All Surface Mining Act, on which the federal program is almost verbatim a match with our All Surface Mining Act amendments. And the list goes on. Very, very fertile time in the environmental history of Pennsylvania. For those of us who believe firmly that we will not make lasting progress in conservation and protection of the environment, will not make lasting progress until we look at protection of the environment and conservation as equal to our law, equal to our economics. I have a little different take, and I hope I'm not wrong about it, but I view the Environmental Rights Amendment and the Robinson Township decision as the first step in really implementing a program that brings that consilience of law, economics, and the environment together on equal footing. It does not mean that economics don't matter. And personally, I'm tired of hearing critics say that if you're a conservationist, if you're an environmentalist, you're automatically against the United States economic system. That's just not true. It's not true on my part. Most of the people that I have known, the overwhelming majority of colleagues with whom I've been proud to be associated in the conservation environmental movement, believe in our economic system, want it, in fact, to prosper because we all benefit from that prosperity, including the environment. But we don't look at economics as being the only God that you listen to. And we haven't done a very good job of coming back at our critics with respect to that. So I'm proud to be here tonight with, and I really want to hear the legal arguments. John Dirnbach has started it. We're going to really ask pretty much the same questions of the panel and give our panel a chance to voice their opinions on the same questions that John Arway had asked John Dirnbach. And then we'll hopefully have a little time for members of the audience to ask questions. There are some here who would have great questions based on my experience with them in the past. So we'll open it up first and foremost, John Arway.
Thanks, Pete. I should point out that we have one other commissioner to join us tonight, Lenny Lickfar. Where are you, Lenny? In the back. Welcome. And I'd like to just start out by saying that when I planned my talk this evening, I remembered a video clip I saw of the famous statesman and comedian Red Skelton telling the story about one of his teachers explaining to him as a young schoolboy the words and meanings of the Pledge of Allegiance. And I really encourage you, if you haven't seen that skit, to Google Red Skelton's Pledge of Allegiance, and you really enjoy Red's definition of what the Pledge of Allegiance really means. Red later wrote down and then recorded his own version, and I thought this approach would be most fitting for my remarks this evening, so please bear with me as I attempt to do the same with Article 1, Section 27. The people, a plurality of persons considered as a whole, which includes all 12 million of us who are great citizens of our Commonwealth, have a right, in accordance with what is good or proper, in conformity with fact, reason, truth, or some standard of principle. The recent Supreme Court opinion clarified that our environmental rights are just as important as our political and other civil rights. Chief Justice Castillo, in his plurality opinion, said these rights are, quote, on par with any other right reserved to the people in Article 1. These would include the right to life, liberty, property, and the pursuit of happiness, freedom of speech, freedom of religion, the right to trial by jury, and the right to bear arms. The Environmental Rights Amendment speaks to the rights of the people. Have a right to clean air, air safe to breathe, absent of pollutants that can impact our health and well-being. Pure water. Nearly 1 billion people around the world suffer needlessly without access to safe, clean water to drink. Safe, potable water free of disease vectors, pathogens, or unacceptable levels of toxins. Water clean enough to support the fishable, swimmable goal of our Clean Water Act in all of our Commonwealth waters. And to the preservation of the natural, scenic, historic, aesthetic values of our environment. To keep all of our natural treasures safe from harm. Pennsylvania's public natural resources, our broad biodiversity and geodiversity that exists naturally, relatively undisturbed by man. Things such as our air and wind, our water, our soils and rocks, our forests, and our fish and wildlife are the common property of all the people. Real property owned by us, quote, the tenants in common, who each have an undivided interest in the entire property of our Commonwealth. Property belonging to each and every one of us, including generations yet to come, even our children yet to be born. As trustee of these resources, those of us in state government who hold power for property or authority are in a position of trust or responsibility for the benefit of the general public. We are the trustee for your property, and you are the beneficiary of our trust. The Commonwealth, a political community founded for the common good, a state in which the supreme power is vested in the people. We are a state in which sovereign power is invested in the representatives chosen by the people to govern. And government is the people, and it's from the people to the leaders, and not from the leaders to the people. Shall conserve, to prevent injury, decay, waste, or loss of our natural resources, and to keep things in a safe and sound state. And maintain them, to keep them in existing condition and not allow further degradation. For the benefit, a good or helpful result, an improvement of our general well-being as a society, of all the people, all of us. It's as much your property as it is mine. Herbert Hoover once said, "All men are equal in the eyes of fish." And now, ladies and gentlemen, let me hear you recite Article 1, Section 27 of our Pennsylvania Constitution. The people have a right to clean air, pure water, and to the preservation of natural, scenic, historic, and aesthetic values of the environment. Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. As trustee of these resources, the Commonwealth shall conserve and maintain them for the benefit of all the people. Thank you.
Thanks. We'll hear a few more words from Terry Bossert.
Well, I'm going to start out just talking about Article 1, Section 27 generally, and kind of what it means and has meant to me. Like Pete, I got to vote for it, fresh out of the Army myself. But then I really became surprised by it, because when I was at the Dickinson School of Law, the Gettysburg Tower case was being litigated in Adams County, the first case to really deal with the amendment. And one of my classmates, actually was a year ahead of me, was a law clerk for Judge McPhail, who was the judge hearing the case. So he and I used to sit around talking about the amendment and what it meant, and the big issue then was it self-executing? Now, I happened to be working in the summers as a summer intern for what was then DER, so I had one point of view. He had a slightly different point of view, but Judge McPhail eventually decided that it was self-executing. So to me, that kind of meant, well, this amendment was off and running, and it was going to be used to judge the activities of all levels of government. Unfortunately, it kind of got shoved off on a back burner. I disagree with John Dernbach a little bit, and I will say as an aside that one of the things I said to Tim is what I really like about this is I get to disagree with John, and he's not here to have a comeback. But I disagree with him a little bit in that I think the Payne versus Kassab test was really a legitimate way to look at the balancing of the interests. I really think the case, not to make this into a legal seminar, that really put the amendment on the back burner was the Cry case, or the concerned residents of the Yaak in 1993 or 94, something like that, which basically said, well, the legislature passed this law, so they did the balancing, end of story, without really looking at whether the balancing they did was the right balancing. So the way I look at it is Article 1, Section 27 creates a very important right in the people. It's a point I'll come back to later when we get into the questions. A right in the people, in the citizens, to judge their actions of their government against that Constitution. Just like the Constitution says you're free from unreasonable search and seizure in your homes, that the government cannot quarter troops in your house except in the time of war, etc. All those things are rights that you as citizens can assert against the government. However, like all of those constitutional rights, it's not absolute. There are limitations put on every constitutional right, including, for example, the First Amendment of the Federal Constitution, freedom of speech. There are some limitations. You know, the old tried and true example is you can't yell fire in a crowded theater, right? But there are limitations, and there are balances. And the question is, how do you balance? And that's why I think the third prong of the Payne versus Kasab decision was really valid. How do you balance, like Pete mentioned, economic interest versus environmental interest? Because let's be honest, the purest environment would exist if we were not here. If there were no humans on the face of the earth, the environment would be a lot better. So we got to decide, how is that balance? And I thought there were a couple things in the Gettysburg Tower case that I just will cite as an example. For one, the court, the majority there, said, it's difficult to conceive any human activity that does not in some degree impair the natural, scenic, and aesthetic values of any environment. It goes on to say if the standard is any intrusion or distraction, there they were talking about the Gettysburg battlefield, it's difficult to imagine any activity in the vicinity of Gettysburg that would not be unconstitutional. Again, saying you got to have some balance. It's not absolute. And then, I'd forgotten about this, but Judge Menser, in his dissent, was talking about, it was really talking about should the amendment be self-executing, but that's not really the point I want to make. He says, what is clean air? Science tells us that air is made up of the following, exclusive of water vapor, and then he gives percentages, nitrogen 78%, oxygen 20.9%, etc., and says, is clean air means water or air containing only those elements and compounds set forth above, plus water vapor, which must also be pure. So the question is that what clean air means? If that's what clean air means, we haven't had clean air in the Commonwealth of Pennsylvania and probably never will, in that there's no activity. If you drove your car here, unless you drove hybrid, you put something in the air. If you have an oil furnace in your home, you put something in the air. So I think the real issue, and I think, and we'll get into the meaning of what the decision means to me, but to me, the real question is, how are these general principles that are in the amendment, how are they implemented in state actions? In my view, it's the role of the General Assembly to decide, in the first instance, how these should be implemented, what entities should implement them, and what the rules should be. But subject always to the right of the citizens to question the propriety of that balance. I think Pete sort of felt like the balance has switched in one way. I don't know that I necessarily agree with that, but I will say, and we'll get into the decision, for everything else about the decision that I don't like, the one thing that I do like is it has put Article 1, Section 27, that provision, which I sat around the Dickinson School of Law cafeteria years ago, debating, I don't want to admit how many years ago that was, has now, as John said, kind of come to the fore, and people can use it, again, to judge the action of the government. And I frankly think that's a good thing. How it shakes out and how that balance is struck, I think only time will tell. But I just believe at this point, I think it's a great guideline, and it's great principles, and it's a great tool for the citizens to use. They just have to be used in a way that supports not only the desires but also the needs of basically the society that we live in. So those are my views. Thank you.
Thank you, Terry. Without going into all of the areas of discussion with John Dernbach, I think one of the key comments that Terry just made, and I think gets to the heart of the question, at least it does for me, as to how you're going to implement this in the future. Are we going to need a statute each and every time we address the constitutional amendment, or are we going to be able to take the police powers, try to limit the police powers in the Constitution as I understand it, the Robinson Township did, without any specific mention of the rights of local municipalities to zone? Or can we take all of the existing statutes today and run it through the sieve of the Environmental Rights Amendment? Could you conceivably do that? Is it impractical? The lawyers in our midst, let's tackle it for a minute. Terry, try it first, and then we'll go to Franklin, and then John.
Well, I think the legislature has already, in many ways, implemented the amendment through the laws that you referred to earlier. I think it would be kind of hearkening back to, British common law 3 centuries ago to have no statutory standards and just say, okay, I'm going to build a mall. I pick on malls because if they were outlawed, that would be okay with me. Okay, so I'm going to build a shopping center. There's no erosion control regulations. There's no stormwater regulations. But here's my plan, and then we'll just judge it on the basis of these principles. I think that would be chaos. I think you have to start with a set of rules. And then I think you have to look at those rules and say, all right, did those rules strike the right balance? Did those rules go far enough? Are they too lax? That would be my view. But frankly, there's things out there already. There's a provision in the municipality's planning code that says timbering is allowed in every zoning district. Well, in light of Robinson Township, maybe that doesn't fly anymore. I think there are those laws that will existing that will be tested against this standard, but I wouldn't want to suggest that we just get rid of standards and do everything kind of on an ad hoc basis.
Well, I agree with Terry. First of all, it was never my intent or any of the people involved with the amendment that it would require any further legislation to implement or make it effective. I always thought it would be self-standing and self-executing. I think Terry's right. What it is a standard against which to test the laws that are on the books or the things that may be passed. But it was not meant to require anything further before it became fully actionable, so to speak. Yeah.
John?
Well, admittedly, I'm not a lawyer, but I am a scientist. So I feel like a rose between two thorns, because I've been on the stand and have been cross-examined by many other lawyers. But from, I guess, a scientist's perspective and being able to read the English language, when I read the Environmental Rights Amendment and I read the Supreme Court decision, it tells me that rather than, politicians judging whether or not our air should be pure or our water should be clean, we should be led by the science that goes behind determining whether it's clean or pure. And if a community or local municipality decides that it wants cleaner water than the state requires, they should have the ability to decide how clean their water should be. Really, that's my interpretation of what I've read. How that tests out, and whether or not municipalities around the state, we've seen municipalities regulate local activities differently around the state over time, and I think this provides a new lens for them to look through to decide how clean they want their local community to be.
But related to that, would you say that, would you set a statewide limit that they cannot exceed certain limits? That the state would define how clean water should be or how clean air should be, and municipalities can go lower, but they can't go higher. It seems to me if they can go higher, then you unleash the chaos that Terry was talking about earlier. Go ahead, John.
Well, I think we do that right now, Peter. We have our, clean air and clean water standards that we've got, that flow from the Clean Streams Law and are promulgated by the Environmental Quality Board that we have in our regulations now that everybody has to comply with and the state regulates. I'm not sure how much of a say local municipalities have in deciding whether a new permit in their township should go beyond what the current state law requires. And my reading is that maybe now they have a chance to do that.
Well, I'm not sure that's necessary. I remember when we were passing the Clean Streams Law, there were a lot of municipalities in Pennsylvania that weren't treating their sewage as recently as the 1960s and 1970. And I know that if the state didn't say you've got to do it, it never would have happened. So I think it's important that the state have some kind of uniform standards so everybody up and down the river know what their obligation is, because it is one body of water from up in Cooperstown down to the Maryland, into the Chesapeake is one body of water. And everybody's got to meet the standard of keeping it clean. Now, I don't see any, I'm not particularly sold that you need to go above that standard if that standard is adequate to keep it clean when it goes into the Chesapeake. That's what. Terry.
This touches on the main problem I have with the Robinson Township case. And that is that it takes what I believe is the rights, the constitutional rights of the citizens, and somehow makes it into a constitutional right of the local government. I remember as a DER lawyer in the 70s, going around making municipalities build sewer systems. And they argued that it was violating their due process rights. And the court said, you don't have any due process rights. You're a local government. You do what the state government tells you to do. End of story. I think what this decision has done is, and what bothers me about the Chief Justice's opinion, which I won't say everything I think about it because I do want to keep my law license, but if the whole decision was based on the rights of the individuals who were litigants in that case, that's one thing. But to now say that a municipality can decide we're going to do something different, you could challenge it. Did the state set the right water quality standard? Use that standard, challenge it, decide whether they've done it the right way. But should every municipality be able to set its own water quality standard? As Franklin said, the stream flows down through. Suppose each municipality decided whether their streams could be stocked or not. That's the problem that I have with the decision. And one commentator, and I wish I could remember who it was, but everybody put out articles after the decision, said that part of the Chief Justice's opinion basically made NIMBY a constitutional right. I don't know if I'd go that far, but at least that was what one commentator said. So I think you have to have standards that are set, in many cases, on a statewide basis and have to consider statewide interests. Now, that doesn't mean that there aren't zoning considerations that, you know, since this is being taped, I won't say exactly what I think about some parts of Act 13, but if there are zoning considerations, those are of a more local nature. But I think, you know, if you go down the road of having every municipality be a mini DEP, I think we're heading for problems.
You know, I would concur with that, but by the same token, didn't Act 13 limit the scope of local municipalities to zone? And whose legislation was that? I mean, that was a particular interest group that passed legislation that said the municipalities have a limited scope in what they can do to zone, and that oil and gas considerations are the only things that fall under the purview of Act 13. So, you know, it seems to me that we can't just say that local municipalities rule with environmental considerations. I agree with you. But the other side of that coin, it seems to me, can't be tolerated either, where you have an historical power to zone left to every local municipality in the Commonwealth of Pennsylvania, and then you want to put limitations on what it can do, saying that the oil and gas industry does not have to live up to any separation or requirements in zoning that municipalities have historically enacted.
Except the municipalities' planning code, well, let's start first. Municipalities only have a power to zone because the legislature said they have a power to zone. And the legislature has already put limits on what they can do in their zoning. For example, there's a whole section that deals with surface mining and other things that basically talks about state preemption. Now, you know, we can get into the weeds on the decision, but were there things in Act 13 that, you know, maybe some lobbyist was able to get into the law that, in retrospect, you shouldn't have gotten into the law? Yeah, there was some of that. But you know, you can put limitations. I think, you know, trying to tell people, and I'll get to this point. This is one of the great dilemmas with local zoning. And frankly, range operates in the southwestern part of the state, primarily where some of the municipalities are the most problematic in terms of their regulation, okay? But the biggest concern was, you say you can have drilling operations in all districts, including residential districts, okay? I think the thing that everyone struggled with is what's the difference between a residential area and a residential district? Because I could show you township maps that would say this area of the township is zoned residential and there's 200-acre farms all over the place. So you could drill there. And I don't think they did a very good job of it, but I think there was an attempt to try to strike that balance. But just putting the oil and gas parts aside, I think the larger issue is, you know, are you going to have statewide standards, or are you going to have, you know, local standards for everything that has an environmental impact?
Describe life before and after the December 19th decision breathed life into Article 1, Section 27. We've touched on it. Each of you, in one way or another, has touched on life before. It was essentially 40 years after the amendment was passed that we really had a decision by the courts that we could sink our teeth into. And, you know, what did it mean to you, Frank, in all those drought years when you couldn't get a court decision?
Well, first of all, it sounds like the Article 1, Section 27 had no impact before Robinson Township, and that's wrong. DER immediately had a form you had to fill out. If you wanted to have an impact on the environment, I forget the number of the form, but some form online or something. But you had on this, if you were going to have ask for a state permit that had an impact on the environment, like a dam or anything, or a landfill, you had to go through this whole questionnaire. How will this impact the environment? What will you do to minimize it, et cetera, et cetera, et cetera. So administratively, DER and DEP were implementing it. I know Ralph Alba and the Fish Commission were doing it with their proclamations. But in terms of if you wanted to get a permit, you actually had to comply with this questionnaire, which was based on Article 1, Section 27, even though there was no court opinion. That was like we have now. So I don't want anybody to get the idea that the FIS thing was dormant. It just was, there was no real Supreme Court decision which really put teeth into it or some life into it. So I think what the Supreme Court did was really say, look, words, English words have a meaning. The plain language counts. So when you're planning what you're going to do with the environment, look at all the plain English of the statutes and the Constitution. So,
John, comment on that?
Yeah, I guess it gave me new hope for my grandkids. Generations yet to come has a lot of meaning within the middle of the article. And for me, I think the hope is that whenever the legislature or the administration makes decisions about how to protect our air, water, soil, and public natural resources, they take pause and think about their trusteeship responsibilities that are in the Constitution. And that pause may cause them to make a better decision.
Yeah, I think that's a good comment. I think that's really what it does. But I would agree with Franklin too. I think many agencies tried to implement it. The PUC for power line siting, PennDOT, DEP. What I think was missing was the feeling that one could rely on the amendment to say, did you do that the right way? When you did that assessment, did you, like the form that, did you ask the right questions in the assessment form? And I think that's kind of what this decision brings to life, I think.
I think they make an excellent point. We've had regulations and laws during my entire career that were gone over by excellent legal advice, and we have made the assumption all along that we were in fact doing the right thing by the Constitution as well as the individual language of the statute that was being worked on at the time. So we've always made that assumption, and remarkably enough, most of that legislation that was enacted and the regulations, the base regulations that were put down in the 70s, we're quibbling over them a lot today, but they have not yet been undone, very thankfully, as far as I'm concerned. And that says a lot about the kind of legal counsel that we had in drafting the regulations based on this amendment and the language of the individual statutes. One of the things I think we've been very fortunate in having excellent legal counsel from the very, very first beginnings of the Department of Environmental Resources. Prior to that, we had very sparse counsel in the 17 agencies that were throughout state government trying to implement various and sundry elements of environmental protection. So, we've made a lot of progress, and I think this helps to clarify some progress that we can continue to make. And appreciate the comments on the part of all the panelists. What I think we'll do now, there are some very talented people in this audience who probably have some questions, and we'll open it up this time to people who have questions. You've got an excellent captive audience here in these three. Have at them. Yes.
Yeah, I've been in environmental work for 30-some years. Actually, while this is not the same as the 70s where there's a huge groundswell, it's the closest thing I've really seen. Witnessed 1,000 people that showed up for Act 78 hearings, DEP hearings. They have so many comments they don't know what to do. never seen such a resurgence of citizen interest. So I think it's a great opportunity. It's, I think, a time again where the citizens are actually leading and really calling into question actions by government, legislators, etc. And using the Environmental Rights Amendment as a screen, well, there's not a lot of new laws and regulations. I think you could use those tenets over the practices of the agencies, the day-to-day implementation of the laws and regulations in the book. So, for instance, I looked at the first one. Is a 15-day turnaround on a DEP permit for a gas well really implemented in the first one appropriately? Is leasing of public lands implementing the public's natural resource commitment for generations yet to come? So you could look at the day-to-day decisions for those screens. And so the question to the panelists would be, would this be a practical application of this beyond any new rulemaking? And, and again, it would be citizen-led, kind of citizens organizing and calling to question the practices in a more organized way. So, Terry, I mean, you were saying you don't feel like every little local government decision could be held up to this. And in a practical sense, maybe that's so. But I mean, what would be a good way to bring this to life besides the legal way? I think there's practical. Practical and administrative way.
Let me just add this. There is one requirement for holding public office in Pennsylvania. You have to take an oath of office. You cannot be a senator, a House member, a governor, or a Supreme Court justice unless you swear to uphold the Constitution of Pennsylvania. You have to do that. So it's fair for anybody to ask anybody running for office how you view any amendment to the Constitution. How do you view Article 1, Section 27? How do you view gun rights or free speech? That's a fair question, because if they're elected, they got to swear to uphold it. So you can ask that question. That's one way you can do that without getting into the legal questions of going into the formalities of getting a lawyer and all the expense of litigation. So I would just point that out. Terry?
Well, to answer your first question, yes, 15 days is appropriate. I think we have to keep in mind that Article 1 of the Constitution has lots of provisions that create lots of rights. And in almost all of those cases, the legislature has taken some action to explain that, to put parameters on it, to have procedures that go with it. So in that sense, this isn't any different. As I mentioned before, you have a right to be free from unreasonable search and seizure. But there's rules and there's laws and there's things about how you go about searching someone's home. Now, can I challenge those and say to a court, that's not implementing it? Yes, I can do that. And I think it works the same way here. You say, all right, here's a law. It says you can do this. Say, well, have you struck the right balance there? And, and everyone's going to have a different view. As my little smart remark before. If you never build another shopping mall, that would be fine.
And the secretaries and deputies of agencies take an oath as well. And so I'm just suggesting there might be a practical day-to-day application. It's not the bigger legal implementation.
Yeah, I was going to say, we had an example of that today at our commission meeting in this very room, when we had a commissioner cite Article 1, Section 27 in discussion of a public policy issue. And as Sidney pointed out, I took the oath of office, although I wasn't elected unless you count 10 commissioners electing me to a position, which was, I guess I won the vote. I took that oath of office very seriously when I took it, and I remembered this article within the Constitution because it's very relevant to the public policy decisions that we have to make as an agency. And it stays with me, and the fact that the Supreme Court decision brought it back into discussion really was reflective in it being talked about today at our commission meeting in a public policy way. So, it would be great to see it come up in discussion at the Environmental Quality Board. when we do public policy decisions with regulations, or in other forums, when people are reminded of what their duty really is. And my hope is that this reminder will keep it alive in those discussions.
John, one of the questions that I have is, Robinson Township, it seemed to me, applied the constitutional amendment to an act of the legislature. As administrative agencies with science making balancing decisions, it's fairly simple to say, did you do it? How do you say that to the legislature when they pass a law? They don't have the background. I fear that what we're going to get to is there'll be a blanket statement in front of each bill where the legislature says we did a balancing test under the Constitution. This is in the public interest. And it really won't change the way in which we legislate. Do you have any suggestions as to how the legislature should approach its duties under this new interpretation?
I really think the duty falls within the respective agencies of the administration to pay attention to what the legislature is doing and counsel them about the areas that they're experts in. If it's an air issue, DEP should be talking to the legislature about what clean air is and what is necessary subject to this standard of test whenever they promulgate new legislation. If we don't, we're derelict in our duty. The same holds true for me at the Fish and Boat Commission. If a bill comes up about endangered species or about native trout or about other things under my agency's purview, it's my responsibility as director is to take notice of those bills and actively advocate for interests to protect the natural resources under our trusteeship.
As a former legislator, let me just say, legislators are not supposed to be experts. They're not there because of their knowledge of science or everything else, so there are a lot of knowledgeable people there. What they're there for is to reflect and make judgments based on the information they get as to what ought to be passed. So if you think there's a subject which is of a technical question, then it's your obligation to get that information to the House members and the senators, because that's why they can act well if they get good information. But expertise in any particular subject never should be a reason for going to the House or the Senate.
Terry, comment?
Yeah, I think John makes a good point. The legislature has done that with other criteria that the court has imposed, and then they make findings. They even pass resolutions declaring their own laws constitutional. So you could see that happening. But I agree with John in kind of two ways. One is it's the duty of the executive and the independent agencies not only to deal with the legislature, but in implementing their own programs. Because most statutes, there are a few exceptions out there, but most statutes say, you got to have a permit and it's got to meet the standards that the department comes up with. And then it's up to the department to come up with those standards. So I think that, you make a good point that it really went to an act of the legislature, but I think its impact is going to be more on the act of regulatory agencies.
John, was what you were suggesting that the legislature, each time they passed a statute, would have an escape clause at the top saying that it automatically complied with the Environmental Rights Amendment, so therefore that case is closed?
That wouldn't mean anything. That language would be worthless.
Okay.
That's what
Good.
the legislature says, is what the court's saying. That's the separation of the three branches of government. So the legislature can say what it wants to, but the courts get to say what it really means and how valid it is.
Good. Yes.
Are the trustees of our resources at this point upholding this article, allowing hydraulic fracturing to take place in our state?
Terry.
Aesthetics, I know, are on the eye of the beholder sometimes, but it's scaring us right here.
We'll start with Terry on this one. We're going to come right this way.
Is your question in the state at all or on the state lands?
No, state lands,
Yeah.
game lands, the lands that many of the
Right.
people
Well,
I'd
I
like
think,
to be Christine.
yeah, and that's where I think you get to the balancing. State lands have been used for gas exploration for many, many years. The fact that the gas is extracted by horizontal drilling and hydraulic fracturing, in my view, and going on the science, doesn't change that. It can be done, in fact, it can be done with less surface impact and less potential impact than the traditional way of drilling a well every, half mile to get to the resource. And there actually are lands, and the company I was with previously dealt with the agency down the road there a little bit, where we could extract the gas from their land without ever touching their land, from drilling from private land. And I think that's a reasonable balance for the experts to make. Should there be controls? Should there be limits like the state has been actively promoting? Yes, there should be. And but I don't think it's a violation of the trust to say that you can have that kind of activity.
The word aesthetic value is really, who decides what is aesthetic?
Well, and that's true. But then the aesthetics are, what are the aesthetics while you're drilling versus the aesthetics after you're done? Is a temporary aesthetic problem, annoyance to somebody? Is that, should that prevent an activity completely? I always like to start when people start talking about this by saying Pennsylvania consumes 900 billion cubic feet of natural gas a year for all kinds of activities. So if we're going to use it, it's got to come from somewhere.
John, I'll give you a crack. We're all going to take a crack at this.
Well, given that we're a trustee for the fish and aquatic life and the reptiles that live in our landscape and in our waters, I feel a personal responsibility to make sure that the actions that we do and the advice that we give to the agencies that have authority to regulate the industry is sound advice. And we have a staff that now are funded through the impact fee to do permit reviews and environmental risk assessment to make sure that happens. I don't believe the science is fully in, although I believe it's in a better condition than it was when we first started mining coal. But back in the early coal days, there was a time when we didn't spend 15 days on reviewing a permit application. We didn't spend 15 minutes on reviewing a permit application. An operator would come in Harrisburg, get a permit, go home and mine coal the same day. Obviously, that wasn't sufficient time to do a risk analysis to make sure that our streams were protected, which is why we're left with a legacy of 2,500 miles of streams polluted by acid mine drainage. We're on a different scale with this industry. We've seen the impacts of hydraulic fracturing on groundwater and surface water and aquatic life from shallow and deep gas. The same kind of methods have been employed in the development of those resources. And I personally witnessed streams in the Allegheny National Forest that had higher chloride concentrations than the Atlantic Ocean at one time because the secondary water flood operation discharges directly into those streams. Those were different standards. Fortunately, we fought to get those discharges ceased, and those streams run clear today and free of chlorides. However, the groundwater is left with a legacy of petroleum hydrocarbons and other unnatural contaminants that still exist. The new industry, the deep gas industry that's come into Pennsylvania, employs in principle the same technology except in a different way. Some of the unknowns can include the higher pressures that occur over a longer period of time within those well bores and the integrity of those well bores over time that we really won't be able to test for decades. Those things concern me, but having the science, the necessary science today to be able to say that those well bores aren't going to be effective in protecting groundwater and surface waters, we don't have today. So we really can't make that judgment in our risk analysis. We can only use the science that we have to be able to advise the EP on how to permit those facilities. Is 15 days enough to do the risk assessment? I would say not. New York says we need more time to do our risk assessments. Is 15 days enough? I'm not sure. DEP seems to think it's enough. We provide advice to them, so in that trustee role, we can only use the science we have available to be able to advise DEP on whether or not to issue a permit.
Well, I want to, shortly after the Robinson Township case, I resolved that I was not going to give any legal opinions on how the case applied to any particular litigation appearing before the courts. And this fits in that category. It's being litigated. There are lots of advice out there, and I'm going to leave this to the lawyers and the litigators.
Good. Well, being a layman, I don't have to abide by those rules. It's a perfectly good question, but there are a couple things about state forest land that we have to detach, as well as state game lands. They don't own all the minerals, which complicates the exploration for natural gas. They do have, in many instances, surface support rights, so they have some control over how those mineral rights that are owned by the private sector are extracted. And I think for the most part, and it is a whole different regime than past exploitation, shallow gas and coal and so forth. I think there is more known. And I think we have the potential to do a better job. Am I convinced that we have enough people? Range Resources will play the game if we tell them the rules. They only want to make certain that their competition has to abide by the same rules that they abide by, and that's fair. And I'm not convinced that we are adhering to the constitutional amendment as a layman with enough people to do the inspections, to be right on top of them. Those well casings are extremely important. What they do and how they do with their waste is another extremely important consideration. There's all kinds of areas for people to take advantage of getting a competitive advantage. And I think it's the role of government, in conformance with this constitutional amendment, to make sure that we have enough people with enough expertise to make certain that they in the field are doing that job. And on state lands, even more so. We have to exercise different spacing rules. I mean, it's not just the drill pads. It's the transportation infrastructure across state forest lands, across state game lands that could cause forest fragmentation. There is some science on the evils of that. So I'm not, without belaboring this issue, because we're going to get back to the constitutional amendment, I'm not convinced that we are doing it with an adequate amount of enforcement, monitoring, and inspection. I think we can, and the reality is that this fuel is going to be a bridge to the future for renewable fuels. And it's going to be exploited. The question is, going to be exploited the right way? Can we crank in some of the protections in the environmental amendment? I hope we do. I'm not convinced, based on what I see, that we're doing an adequate job of it yet, and I just hope that we'll continue to apply those pressures.
If I could just add, because it touches on something that Cindy said, in terms of, and the question about the trustee rule. I mean, there are rules that DEP has that apply everywhere, but if you want to lease from DCNR, there's a whole set of different rules that they, and I think in their role, as they see it as the trustee of those public resources, have said, you got to do it this way. You can only put a road here, or you got to use an existing road. You can only put a pipeline here. So, I mean, I think there's an example of a way that entities are taking this seriously, even without the Robinson Township case.
Terry, what if DCNR made the decision that there should be no further leasing on state forest land until they understand what the impacts will be of an existing existing 700,000 acres of state forest subject to those leases. What if they made that determination specifically and informed the governor of that? But the governor, and again, beyond the governor, the legislature, made the decision to require DCNR to lease more state land for gas extraction.
Well, I probably have a conflict because Range doesn't lease any state land, so I don't really care if they say you can't lease state land. Well, I mean, that's a good question, because I think that goes to what John said earlier. It certainly couldn't be on a whim, but if DCNR says, look, we've decided that more leasing is going to be detrimental to the the health of the forest or the certification that the forest has, and the legislature ignores that, then I think that's where this comes in. Then the citizens have a right to say, well, wait a minute, the experts told you you're going to mess it up, so you shouldn't be doing that. Now, I think you can have differing opinions. There might be someone else who says, well, yeah, you can do a little bit, or you can, apparently someone felt you can do non-surface exploration, and maybe that's a valid decision. But I think that's, again, where this becomes the litmus test to apply to that.
Rick,
I want to follow up on a comment you made earlier.
speak up so the people, can you hear in the back?
Comment that Pete Duncan made earlier about the staffing. When you're inside an agency, you have a lot of discretionary authority about how regulations are managed, how programs are managed, to carry out the intent of the legislation that you're operating. The constitutional amendment gives you the capability to lean at least in the direction of protecting the environment and conserving resources. This amendment, or this case, the amendment will have new life if we have people in Harrisburg in the agencies, and it's got to come lead from the governor's office, to say this is important and the words mean what they say. If that message comes down, you have a lot of people in these agencies who are good people, they want to do the right thing, they're professional, but they got to know somebody's got their back if they're going to come up and they're going to make that extra, they're going to lean a little bit to the one side to implement that legislation. Right now, I would argue because of the staffing requirements, there are people in the agencies right now to do the job anywhere necessary to do what that amendment says. There's no way in hell, and I've met with the DEP oil and gas people, and I questioned them. I said, I would like to see a workload analysis about how many inspectors you need. We laid out the whole job, how many work years you need, so that generates number of people, and how many people you have. They had 10% of what they needed to do the job, and the explanation was, well, there's only, the bad actors are only a very small number of people, so they're the only ones we have to worry about. That was a way to justify the staffing. So this amendment only will, I agree that it's going to, the life will come from the people in the agencies who feel that they have the flexibility to give this life. If they don't, we're going to be back fighting with the General Assembly time and time again on the laws.
Just as an aside, Rick, and related to that, I would have been much more comfortable had the Department of Environmental Resources, it was still had merit, that whole concept. But DCNR, if they had taken state forest land, a small portion of state forest land, and taken the time to collect the data, to refine the science, I would have been much more comfortable personally had they taken a small fraction of what they agreed to begin with. But it seems to me that everybody got money happy. They took a much larger chunk than they should have, and now they're going to take the rest. And it just occurs to me that that's not wise public policy. We don't have even a fraction of the answers that we need long-term. And a lot of that will be provided on private permits. But I think that there are special cases where state forest land and state game lands, for that matter, they're some of the most priceless assets, and I would argue one of the best bargains that the Commonwealth of Pennsylvania has ever invested in, both their wildlife lands and their state forest lands and state parks. And I think the people of Pennsylvania have a right to insist to us to be very, very careful with those resources. And, you know, that stuff. Other comments? Any more questions? This has been good. I think we all owe a deep gratitude to Franklin Kury for having the vision. Franklin was a different legislator. He was much, much smarter than the average. He thought, he thought longer term. He had a vision. He knew what he wanted to do. I think it was that good Penn Law School training.
Well, that was helpful.
But we all owe him a debt of gratitude, because while we aren't certain today what the future of this environmental rights amendment is going to fare with respect to the courts, with respect to how we regulate, but we're on firmer turf than we were just a few short months ago. And I'm counting on the lawyers with great talent, like we had in the the late 60s and the early 70s in the Department of Environmental Resources, to figure out ways to convince the courts that we need to be ever vigilant with respect to the implementation of the Environmental Rights Amendment. So with that, unless there was one more question you had. Well, this is it.
All right, well,
Okay.
I guess this is primarily for Franklin Kury. Very early in this session, you said, you know, just the plain English language that made this powerful. It made it accessible to everybody in the 70s, and now, you know, when we legislate, bills are 30, 40, 60 pages, even at the state level. You know, when some of the other things that he did were stormwater and floodplain, 6 or 8 pages. You can't even revise them without 60 or 80 pages. Is that a good trend, or can we take from this, you know, the idea that the simple, straightforward language makes?
Well, I think it's a great question, and I think the straight language is important, because constitutions are only as good as the people for whom they're enacted. If people believe the Constitution, that gives it strength. And for the people to understand the Constitution, it's got to be in relatively straight English. And let me just give you one example of how what you're talking about can apply here. You remember this last week, the United States Supreme Court declared that part of Obamacare was unconstitutional, because a company should not be required to provide contraceptive to its employees if they. That was done on a simple, by interpreting the simple language of the, I think it was the Second Amendment or First Amendment to the U.S. Constitution on freedom of religion. The Obama statute is 1,200 or 1,500 pages long, but it applied against the test and it was knocked out. And I think no matter how complicated legislation gets, you still have straight, simple language to test it against. So I feel good about it. I think it should be. I think constitutional provisions should be simple, should be broadly stated, and should be easy, relatively easy for anybody to understand.
That concludes the evening. Thanks very much.